in re the estate of, no, this is not an, yeah, it is. In re the estate of Janet Malik.
Good morning again, Your Honor. John Mayville on behalf of Gerald Malik, the representative of the estate. What I have done, Your Honor, is I have filed a petition under Section 201 of the Trust Code, asking the court to, weigh in on this particular case. You may remember the history is that there was a fuss about who was going to be the representative of the estate. That eventually was determined that it would be Gerald Malik, the one who was acting as its representative. I was advised eventually by Mr. Malik that he would like to purchase the real estate that was the subject. In the process of getting ready for that, I realized that this was actually not part of the probate proceedings because the deed had been done by the Maliks. They had actually conveyed the real estate to the trust. And even though we can't find the trust, and we are also unable to find a will that may have been done by Mrs. Malik before she died, in talking to the title company, they said they're going to require an order from you before they're comfortable letting the trustee deed the property out, regardless of whether it's to him or to someone else. So that was the reason for my filing of the petition and requesting your assistance. I have set forth in the petition a proposed contract for your approval. I have also I thought you would want an appraisal of the property, so I have contacted Raleigh Appraisal. They have advised me that they can have an appraisal done in 2 or 3 weeks. So what I would like to do is I would like to set this over for hearing in approximately 4 weeks, if that suits the judge's schedule. And at that time, I would be prepared to go forward, I think, with an argument regarding our petition. And I would hope at that time to have been able to provide you with a copy of the appraisal done by Raleigh Appraisal also.
All right. Now, Ms. Carlton is here, and I see
Yes,
Mr.
ma'am.
And I see Mr. Smith is here as well, although he's withdrawn.
That's correct, Judge. I'm just here as observing as we have a judgment for fees that was to be paid from our client's share of the estate.
Okay. Well, Ms. Carlton, have you obtained new counsel?
No, sir, I have not, but I would like to make a statement if possible.
You would like what now?
I would like to make a statement on my own behalf if possible.
All right.
Okay, can I go along?
Just tell me what you want to say.
I would like to respectfully place several concerns on the record regarding the administration of my mother's estate. First, I have concerns regarding the accuracy of the inventory filed. The initial paperwork listed nil savings and possessions, which I believe is inaccurate. My parents had savings and a lot of personal property. I respectfully request that a full account inventory be required and verified. Second, my brother has been living in the estate home for approximately 18 months now. To my knowledge, the property has not been listed for sale. I was not aware of his interest to purchase the home. I'm a little confused about his interest to purchase the home 18 months later after he has proceeded to live there free of charge for the last 18 months.
Ma'am,
Yes.
ma'am, here's what I'm going to do. Mr. Mayville has asked me to set his request for an order directing the sale of the house out of the family trust.
I agree with that.
He's asked me for 4 weeks to set that matter for hearing, and what I think would be appropriate is for me to set the matter for hearing, and in the interim, you have a conversation with Mr. Mayville about your objections, whatever, and then anything you can't satisfy, you could raise it at that hearing. It's always preferable to me if you raise your objections in writing first.
And Your Honor, thank you.
Okay?
I do have objections because I have not received any information on the damage of the flood, the insurance that was covered and what was spent.
Okay.
I received nothing.
And you know what? I don't have anything in here indicating that a final report has been filed yet. So there wouldn't be an inventory yet. Okay? But let me set this for hearing in about 4 weeks. Mr. Mayville, could I do this on a Friday afternoon, the 27th of March at 3 o'clock?
That would be fine with me, Your Honor.
Would that work for you, Ms. Carlton?
Yes, Your Honor, it would.
All right. Now,
My-
hang on
Yes.
just a minute. I'm just writing it in. We're gonna do that at 3 o'clock, Friday, March 27th. That will be in courtroom 3. You may be present in person if you wish. And if you have any objections, it would be helpful to me if you could file those in writing within 21 days with the
I will
circuit.
do that.
All right. Before you do that, please contact Mr. Mayville and see if you can work out any of your differences prior to your filing.
I will try to do that as well. However, Mr. Maybell has not been very cooperative or kind to me in the past.
Okay, well,
I will try.
all right, and I will tell you that Mr. Mayville is going to tell you, give you his honest appraisal of what he thinks. He is not your attorney, and I'm sure you recognize that.
I
So-
certainly do. I recall him
Don't-
attacking me on the stand when I was there.
Okay, don't mistake his disagreement with you for a lack of kindness.
I made
Okay.
that reference because he attacked me on the stand when I was in the hearing and you witnessed his behavior towards me yourself.
I did not witness anything inappropriate. I have never seen Mr. Mayville do anything inappropriate in court. Okay? Again, do not mistake his disagreement with you as anything other than his representation of his client. Okay?
I understand. My only goal is to preserve my mother's estate and ensure that no heir receives unequal benefit at the expense of others. That's my only concern, Your Honor.
And that's fine. That's fine. And we'll talk about this at that hearing. Okay?
Okay, thank you very much for your time and consideration.
Thank you, ma'am. We'll see you on Friday, March 27th at 3 p.m. And we'll take up your concerns. Okay?
I will file my objections within 21 days, Your Honor. Thank you again for your time.
Thank you so much, ma'am.
Thank you, Your Honor.
Thank you both.
Your Honor,
Yes.
this is William Lund. I'm one of the heirs in this case.
Yes, sir.
I guess I'm wondering what the status of the grandchildren were. I'm not sure if either of my sisters or my brother are on this conference call, but I'm here, I guess, not as an attorney on their behalf, but just kind of wondering what's going on their behalf.
Well, I will tell you,
I guess, what is our status?
Patrick Malik is on the phone. On the call. Cheryl Carlton is on the phone, or on the call. They're all here virtually, and Mr. Mayville is here. Again, you need to call Attorney Mayville because he represents the administrator of the will and or trust. I mean, we don't know who the trustees are. We don't know. So is he the executor or the administrator, Mr. Mayville?
He's the administrator, Your Honor. We never could find the will.
Okay, thank you, Mr. Mayville. But call Mr. Mayville and he will give you an honest assessment. Again, if you think your interests are contrary to his, as an heir, you know, you're entitled to either participate like you are today, or ask the administrator for information.
Okay. He's not very receptive at returning phone calls, but from my last experience of getting a hold of Mr. Mayville, but I will attempt to get a hold of him.
Okay. Well, you need to make sure that you leave him the name of the matter that you're calling on, and a return phone number.
Oh, that was absolutely left every time.
All right, sir. Good luck.
Thank you, sir.
Thank you. Willard Staver versus David Baker. The other is in re the guardianship of Ariana Baker.
Good morning, Your Honor. Rebecca Lamb on behalf of the Guardians.
Good morning, Attorney Lamb. Make sure after today, I know why you're here.
Yeah.
Okay. And
Unfortunately.
make sure you give my condolences to Attorney Gerken.
Yes, Judge, I will do that.
Thank you.
Thank you.
Attorney Obert, you here on this one?
Yes, I am, Your Honor. I am here on behalf of Ariana Baker. I'm representing Attorney Crow today as guardian ad litem.
All right. I take it we're just gonna continue this for a little while?
We're here.
Oh,
We're here.
okay, they're here.
And Your Honor, my understanding is at the last court date, you ordered that the GAL fee should be divided equally. Attorney Crow has moved forward and filed a report on guardian ad litem fees in 2019 F23 and 2025 GR24. We would be asking that they be entered today.
Okay, let me take a look at them. All right, is it the same in both matters?
It is different in both matters, and I will let the court know that our office did receive.
I'm looking at the other one. Okay. All right, yeah, okay. In one, it's, I think, 481, and the other, it's 1081. Correct?
Your Honor, in 19F23, Michelle and Willard Starver owe our office $1,081.75. Joseph and Goldie have paid in 2025 GR24. It's $461, and our office did just receive payment from Joseph and Goldie, so it's just $461 against Michelle and Willard.
Are you Michelle and Willard? All right. So what do you have to tell me?
So we were confused about the order because during the time when we were going for guardianship, or trying to maintain our guardianship, we kept Ariana on our medical, and all of the medical was taken care of through us.
This doesn't have
And
anything
school
to do
fees.
with medical expenses. This is
The
the
guardianship fees?
guardian ad
Oh,
litem's
yeah, we'll
fees.
take care of that.
Okay,
Absolutely, yes.
okay. Well,
It just had to be split, so we'll take care of that.
I'm not sure what else we're here for.
So Judge, if I may, we are here, at the last court appearance, the court issued rules to show cause against both.
Michelle and William.
Correct, Your Honor. And the main issue, there's a few, but the main issue is that Social Security benefits have not been turned over as ordered in the court's November 2025 order. So Ms. Gherkin was looking for an order requiring that those be turned over to our office within 14 days.
May I address?
Yes.
may I speak? Your Honor, we provided Ariana's medical care during that time. I have EOBs and insurance premiums that were paid on her. So she was covered under our medical insurance, and we paid for her school fees during that time. So we were confused about the amount of Social Security that should be turned over since
All of it,
since we had
all of
we
it,
were paying the medical fees
all of it,
and her medical insurance premiums.
all of it.
That,
Because your insurance was paying those medical bills, except for the co-pays, right?
well, we were paying the insurance premiums. We paid $12.45 a month.
You've got
For
that
insurance.
insurance whether she's there or not there. You turn all of it over.
Okay.
I will enter an order that be turned over to the guardian ad litem within 14 days. Please put in the order the amount.
Judge, I'm not sure that we have that information.
Well, put in at least the benefits for what months.
Of course. And then, Your Honor, there's also an issue with the Social Security card and birth certificate. Those originals are still in possession of the former guardians, and we've asked that those be produced and provided to our office. And then there's also an iPad and a cell phone that belonged to Miss Baker's mother, who's deceased, and we were asking for
Okay,
turnover
just a
of that.
minute. One thing at a time. What about the vital records, Social Security card and birth
We
certificate?
mailed the Social Security card
When?
previously. I believe it was in October or November.
And they still don't have it? What about the birth certificate?
But they are the legal guardians, so they can file for those records now. We don't have those.
You don't have either the Social Security
don't,
card or the
sadly.
birth certificate?
No.
Did you hear what they said?
I did, Judge. We did not receive anything by mail, and we've been able to obtain copies, but we'd like
You
the
could get
originals to be
duplicate
returned.
cards and a duplicate certified original birth certificate, right?
Correct, Judge. We have been able to obtain copies of those. I think the concern was that they wanted those documents returned.
Okay, well, I am gonna order you to search your records, files, make sure that you don't have those documents, and either provide them to the GAL, the current guardian, or give them something in writing, signed, saying that you've searched your records and you do not have the originals. All right? And then there was the issue of what?
Judge, there is an iPad and a cell phone belonging to
An
the
ICANN?
iPad and a cell phone.
Oh, iPad,
Yeah,
Gotcha.
a tablet device, Your Honor, and a cell phone that still need to be returned
Okay, and who do those belong to?
to the ward's mother, Your Honor. She's deceased.
Okay. Do you have those?
We have looked and looked and looked. We don't know what those
Same
items
thing.
are.
Kill it all with one letter. Search around, see if you can find them. If not, just give them a letter saying, I looked for these items, and either we found them, and here they are, or we didn't find them. And it'd be really helpful if, I'm not gonna make you go get a notary or do it under oath, but I want you to sign whatever you send them. Okay?
And Judge, we also, Attorney Gherkin had asked that she have leave to file a petition for attorney's fees as well and costs.
For having to file this motion?
Correct, Your Honor. There were also some transcripts, I believe, that were ordered, so we have some costs.
Were the transcripts ever used in court?
Judge, that, let me check her petition here. I believe they were necessary.
I'm looking to see if they're attached. No, I don't see
It
it.
looks like it was sent, to William and Michelle's attorney to prove that the order was correct. That was back in April of 2025. So, but she's also got some time in, obviously, related to the petition and serving a rule to show cause on each of,
All right,
Yeah.
well, I will have, let's come back then in 4 to 6 weeks.
We could do March 31st, unless you wanna go to April, sir.
You wanna do March 31st?
I think that should be fine, Judge.
What time?
At 9:15.
All right, and have her file that petition, within, under the circumstances, I'll give you 28 days.
Thank you, Judge.
Thank you. And, we're gonna come back. There's, under the rules of civil procedure, for having to file a motion for contempt. If the court finds that the failure, to comply with court orders, was in essence willful, then, they are entitled to recover their attorney's fees for having filed the motion for contempt, which is the motion for rule to show cause. Because the full title is Motion for Rule to Show Cause Why You Should Not Be Held in Contempt. All right, and you will be sent a copy of that fee petition, and you will have an opportunity to be here at least one more time on that petition. And if you want me to give you time to file a written response or to have an attorney file a response on your behalf, just let me know, okay? But we're gonna be coming back on that matter on March 31st at, tell me again,
9:15.
9:15
And I
a.m.
need to appear or provide a written response.
Either, both. Okay, but you can't file the written well, I suppose you could, because she's just filing the petition for fees now. What you need to explain to me is why your failure to comply with the court order to turn over those things was not willful. Okay? If you did it in good faith, then she's not entitled to her fees. But if I find that your, was, and it's a little higher than just willful, but if I make that finding, then she will be entitled to her fees. But only those fees associated with having to file the motions for contempt. Okay?
Okay. Thank you.
Good luck, folks. We'll see you in March.
Okay.
Thank you, Judge. I'll submit an order.
Thank you.
Do you want Attorney Crow to appear on March 31st as well?
Unless, only if she wants to.
Okay, I will let her know.
Thank you.
Thank you.
Thank you.